Thank you, Mr. Hivner. Welcome to you, Mr. Womack, Mr. Mays, Mr. Bass. We're glad to have you here on behalf of Judge McBrayer, Judge Golden, and thank you for agreeing to embark on this video journey with us. And if we don't have any questions or concerns, let's call the first case or next case, Mr. Hivner.
Yes, sir. Jennifer Carman et al. Versus Joshua Kellon et al.
Good afternoon, Your Honors. My name is Andrew Womack. I am an Assistant Attorney General with the state of Tennessee. Before you this afternoon, on behalf of the state of Tennessee, and the state would just like to take a very quick minute at the outset to make its argument regarding the constitutional challenge that was raised at the trial court. During that level of the litigation, the trial court determined that the statutory cap on non-economic damages was unconstitutional. Between that ruling and being before you today, the Supreme Court of Tennessee had taken up that issue and issued its ruling on the matter in McClay v. Airport Management Services, LLC, in which the Supreme Court of Tennessee determined that the statutory cap on non-economic damages was indeed constitutional. That is the extent of the state's argument, simply that the McClay ruling is now binding precedent on all courts within the state, and that the state would respectfully request this court reverse the trial court's ruling regarding the constitutionality of that statute, and would yield the remainder of the state's time, with the court's permission, to Mr. Mays and the appellants. Thank you.
Thank you, General Womack, for your presentation, and we appreciate all the work that went into it. Okay.
Good afternoon, Your Honors. Lance Mays. I represent Dane and Jennifer Kellon, and just want to start out by saying that in my opinion, this case is difficult in that it's my position that the law of negligent entrustment has basically been changed, and it would remove both the TBI jury instructions on negligent entrustment and change those. And there are approximately 800 to 900,000 people in Tennessee between the age of 18 and 35. And essentially the ruling of this court on the negligent entrustment, the way that they interpreted it, would make the parents of those 800 to 900,000 residents of Tennessee potentially liable, and maybe even the siblings liable if they reside in the same home. And if allowed to stand, negligent entrustment would be changed in the fact that the judge used the term imputed benefits as a reason for finding liability for negligent entrustment. And the facts of the case are undisputed, and they're pretty straightforward. Joshua Kellon, who was the person driving the vehicle, had a valid driver's license. The lien on the truck was in Josh Kellon's name. The title on the truck was in Josh Kellon's name. All the maintenance was paid for by Josh Kellon on the truck. The tires were paid for Josh Kellon on the truck. He made modifications that he needed to for his landscaping business, short of tires, hauling systems, a fifth wheel attachment that were all paid by Josh Kellon. He claimed this on his taxes for business purposes, this truck. It was a write-off. And he was using it for work purposes on the date of the accident. And it's also important, I'm sure Your Honors have read it, that Dane Kellon was not even in the state of Tennessee at the time that he woke up that morning and at the time of the accident. She was actually in Missouri at the time. The plaintiffs in their brief rely on some crimes of Josh Kellon, but I think it's important to note what those crimes are. He was found guilty of a DUI 15 years prior to the accident. 14 years prior to that, he was actually found guilty of a DUI. And 2 years prior to the accident, he was charged with reckless driving. Other than those three charges, there was no other driving infractions that were called, but the plaintiffs do highlight that there were several paraphernalia charges, which we would merely submit are not relevant because at the time the paraphernalia was found on the vehicle, he was never charged with a DUI at that time. There was no illegal drugs or alcohol found in his system. And the imputed benefits that the court, I would assume, relied on is that he lived at home rent-free. Dane Kellon paid less than $1,500. She kept a running invoice on the refrigerator. And the proof's undisputed that Josh Kellon always repaid that. And he was allowed to use his deceased father's card for some gas purchases during the winter months, which he also paid back.
Were there purchases of or money given to him for gas?
During that particular month, no proof was submitted about how much, if any, was used, but it was undisputed that a gas card was used and he would pay back that card, the gas used on that card.
What about, were payments ever made on his behalf on the money owed for the truck when he had a bad month or something?
The proof was, Your Honor, that basically during the winter months when the landscaping business was slower, that Dane Kellon would sometimes make payments on the loan, and that did occur in the month of March, which is the date of the accident in 2017. The proof is also undisputed that that money would always be paid back once he started back at the end of March, beginning of April.
So how is this case different from the Watrous versus Johnson case?
Well, in Watrous versus Johnson, Your Honor, the first fact to note is that was a summary judgment case. And in Watrous, the issue for the jury was, did the Watrouses repurchase the car? So the court actually used the term repurchase. And in addition, I think this is vastly important to the court since you brought up the Watrous case, is in the Watrous case, the parents retained a security interest in the vehicle, and they felt that it should go to the jury because, in fact, it was, as again, they called it a repurchase of the vehicle with that $500 title loan. And that's different than the facts in this case. And Watrous also noted the reason Nicholas v. Atnip did not apply in that particular case because the Atnips paid for tires, occasional gas money, and payment of insurance premiums, but they found they were not the supplier or the entrustor of the vehicle because the son in Atnip had held the title and he purchased it with his own funds, exactly the same as this case. So the Watrous case turned on whether this was a repurchase for the $500, and it said it had no opinion of the ultimate resolution of the case, but it felt like because there was an ownership, that case became important to them. Plaintiff, the appellees also rely on West versus East Tennessee Pioneer Oil. And again, the facts are different in that the employee at the time knew that the driver was intoxicated and provided them the gas. So that was the entrustment, was providing them the gas at the time, knowing that it was an intoxicated driver. In this case, Ms. Dane Kellon didn't see Joshua Kellon after 10:30 the night before the accident and was in another state during the time of the accident. So there was no communication, no phone calls. So in either case, I would submit that Watrous would support that this is not a negligent entrustment because Josh Kellon is the owner. I would also submit that West versus East Tennessee supports this case in the fact that she had no knowledge of what he did that morning. She didn't know what time he'd get up, didn't speak to him, had no ability at all, even assuming that he was in some state not able to drive. And she could not have forbid him from driving anyway, which we also argued in our brief about control. And ultimately, that's what a lot of this comes down to is the court felt that the imputed benefits gave some right to control, even though ownership was with Mr. Kellon, the maintenance was Mr. Kellon, and the use of the vehicle was for his business. And if you start breaking down, just briefly, I'll get back into it in my rebuttal, but if you start breaking down what's required in 5.50 of the jury instructions, you have to have ownership. There's no ownership here, so that was not applied. And the entrustment, the case law is very simple. In Watchers, the important thing also is the entrustment is at the time of the entrustment, meaning the purchase of the vehicle. So at the purchase of the vehicle, that was purchased by Mr. Kellon with his money, not Miss Kellon. Miss Kellon never drove the vehicle, and nor did she pay off any title. It's more that she loaned him some money, which he paid back, which wouldn't necessarily give a right to ownership, and she certainly did not hold any kind of security interest in the vehicle. Thank you. Unless your honors have any questions, I believe that's my time for the moment.
Okay. Thank you. Mr.
May
Judge?
it please the court, and thank you very much. This is my first time doing this by Zoom. I appreciate everyone. If at any time you can't hear me, please let me know. We did a little checkup in advance. I just want to make sure. I'll try to read faces, but let me know if for some reason the magic of the internet is not as magical as I hope. This appeal is too little too late. Let's start with why it's too late. That is really dispositive of every issue that they would like to raise. Frankly, sitting here now after listening to appellant's argument, I'm still unclear of what exact orders or rulings they are challenging. But based upon the briefs, it appears that they are challenging the denial of their motion for directed verdict. They did not file any post-trial motions. No motion for new trial. No motion for judgment notwithstanding the verdict. No motion of any title whatsoever. Rule of Appellate Procedure 3E is unequivocal. The failure to file post-trial motions waives all issues for appeal with regard to the conduct of the trial. The case law is clear. That includes, the rule on its face says that includes jury instructions. While they've talked about in their briefing, the jury instruction that was used, that was waived. The case law says that includes motions for directed verdict. It's been unequivocally and absolutely waived. They are too little too late. Despite being too little too late, I haven't heard it mentioned here today, but appellants have argued plain error. They are trying to throw a Hail Mary from inside their own end zone and argue plain error in a civil case. Plain error in a civil case in which the appellants were represented by counsel at every stage of the litigation and appeal. Plain error in a civil case in which they, first time that I am aware of, and I reviewed the case law, I cannot find any circumstance in which plain error was used as a means to review the denial for motion for directed verdict. It would be a once of a kind opinion here in the state of Tennessee. Never been done before. Where the plain error doctrine has been applied under the rules, in Waters v. Coker, our Supreme Court outlined that it is an extraordinary relief. It is to be used when the fairness, integrity, or public reputation of judicial proceedings is at stake. What you just heard appellants argue is debating facts, debating the weight of facts. That is not an attack on the fairness, integrity, or public perception of judicial proceedings, and it is absolutely the appellant's burden to indicate every basis for plain error review. One of the factors in the criminal cases that appellants have cited, there's a case in there, State v. Hill, from the Court of Criminal Appeals. In the Court of Criminal Appeals, primarily, they have adopted 5 factors in determining whether or not plain error review is appropriate. One of those factors is that a clear and unequivocal rule of law must have been breached. Now, if a trial judge erroneously instructed the jury that a beyond a reasonable doubt standard should be used in a breach of contract case, for example, that might be such a clear deviation from black letter law as to merit peeking behind the curtain. Here, weighing out under the facts, whether the appropriate, it's hard to say exactly, whether the judge used the right jury instruction in evaluating directed verdict. That may be what they're arguing, whether the judge instructed the jury appropriately, despite the defense consenting to the jury instruction as given and agreeing it was a fair statement of the law. They liked another instruction better. But after, as appellate has pointed out, after several pages in the transcript of discussion, of getting down to every word and should this be a "the" or should this be an "a"? Should this be a semicolon or should this be a comma? After all that discussion with the court and the parties, appellants consented to that jury instruction. Again, I'm unclear what they're seeking an appeal for. They haven't preserved anything. So if we're going to get into the facts, then let's turn to why it is too little anyway. Why the law of negligent entrustment has not been violated, as appellants would have this court believe. Appellants have argued repeatedly that for some reason, when the words negligent entrustment are used, the entrustor or the supplier must have had instantaneous, acute knowledge that the user, in this case, Joshua Kellon, was intoxicated at the exact moment at that time. That is not the law. The law of negligent entrustment is the same as the law of negligence generally. As this court has said time and time again, foreseeability is the test of negligence. The question is whether any rational person in Dane Kellon's shoes, knowing what she did, what she was on notice of about Joshua Kellon, would be or should have been concerned about him operating a motor vehicle. Now, when we ask whether any rational person, in this case, we know that the judge did not direct a verdict. We know that 12 unanimous jurors all agreed she knew or should have known that this man was a danger to society, that this man did not need to have unfettered access to a vehicle. What did she know? It's in the record. First, she acknowledged what we all know, that everybody who drives under the influence is a danger to everyone else on the road. She acknowledged, this is the part she acknowledged, she knew he'd been arrested for alcohol-related charges in the past. She knew he'd gotten at least one DUI, a few drug charges, but she said she didn't know how many. Her only son, she says, I don't know how many drug charges they are.
All these charges were a while back, weren't they?
They were not all around back with respect, Judge. One of them was a year before. Another was 2 years before. He had a number of charges going back quite a ways.
Was there any alcohol or drugs involved in the accident before us?
In this case, Judge?
Yes.
Yes, and the proof went in the record from his criminal conviction that he was under the influence of multiple narcotics. And to dovetail from what you said a moment ago, Judge, contrary to appellant's argument that the evidence is undisputed, he said the evidence is undisputed and that that Mr. Kellon had no alcohol-related driving charges or drug-related driving charges for years. That came to test at trial. They made the same argument to the jury and opened the door. It's in the record, volume 7 at page 235, where it came in that the reckless driving charge that was reflected previously as a conviction for reckless driving, he had been charged just a year earlier for another DUI. He pled it to a reckless driving. Do we know for sure whether that was one of the multiple occasions Dane Kellon went to go pick her son up from jail? Whether that was one of the multiple occasions she bailed him out for jail? Whether it was one of the multiple occasions that she went to take him to a probation officer or drove him around because he'd lost his license? No. She said she purports to know nothing. She purports to remember everything that was said in deposition testimony. But her only begotten son, she cannot tell you why she bailed him out of jail, how many times, how many of them are drug-related or anything else.
But how did she have the power and means to control her son's car directly?
She acknowledged it it's in the record, volume 7, page 219. She acknowledged it outright first. She said she has, in the wintertime, when he has no money, yes, she has the control over whether she makes a payment to cover his pickup truck because he cannot afford to. The jury also, on this standard, to the extent this is directed verdict argument, to the extent we are peeling back the curtain and plain error would somehow apply, then all reasonable inferences are to be taken for the appellees, the Carmans. So we take what we know from her, plus inferences based on what we know there were good reasons for this jury to question whether the Kellons were accurately letting on to all that they knew and all that they had done. She paid the banknote every year. Contrary to what appellant's counsel just said to you, that there was no evidence in the record, she changed her testimony from deposition and had to be confronted with it. It's at volume 7, page 200 through 202. She confirmed in deposition, sworn deposition testimony under oath, and she acknowledged at trial that she had changed her testimony when she got on the stand. She said she paid it every December through March for 4 months of every year. Since the year he had bought it several years previously, she paid every banknote for his $450 every one of those months. She tried to waffle at trial and say, well, not all the time and not every year. She testified unequivocally she always did it. And this occurred at the tail end. This crash occurred in March. It occurred in.
Did he always pay the money back? And does that matter if he did?
Respectfully, I do not believe it matters if he did. The question is whether she has negligently supplied him, negligently entrusted him with the means to do harm. The fact that he may pay her back at the end does not mean that sitting there in March of 2018 when he ran off the road and ran over a doctor on the side of the road, that car would have been in the impound. The bank note was way overdue, but for her paying it every single month. She's putting the gas in there.
I don't understand that comment. The bank note was way overdue except for her paying it every month. I mean, it was,
yes.
So it was current, in other words.
It was current because she had paid the last 4 months of that year.
Don't sometimes people drive around behind on car payments?
They do not drive around without gas, respectfully. And she paid for his gas in the winter months by providing him with a shell card for all of December through March, according to her testimony. That truck was either gone or on empty for a 4-month period. If this coincidentally occurred in July of the year, when it was months after he, according to the least reliable witness in a trial, Josh Kellon, according to him, he paid her back. Now, let me elaborate on that first. There is nowhere in the record that he deducted this from his taxes. All the statements that appellant's counsel made about how Mr. Kellon treated this vehicle, those are not to be found in the record. But regardless, even if we assume he pays her back at the end, the question is whether she has enabled him with means to operate that vehicle. But for her doing so, he would be unable to.
I mean, I just don't understand why this is not just like Nichols against Antip.
In Nichols versus Antip, they made no direct payments for one thing. And in fact, in Nichols v. Antip, the Court of Appeals in that case specifically commented that I believe it was parents in that case, had not paid towards the vehicle. They'd made modest contributions towards maintenance and insurance. They had not been paying towards the vehicle itself. In this case, beyond Nichols v. Antip as well, Judge, she provided him, in her words, her testimony, she gave him a place to live and all other necessities of life, and that is how he is able to pay for his truck at all. So what we have in this case is total financial domination. He is 100% dependent upon her. And that by itself should be enough. If the person otherwise can't go to the bank to pay their note, other than the fact that there's money in the jar at home. But second, she's directly paying the bank note. Third, and this is not one payment, this is pervasive payment. She's paying a quarter of his banknote payments overall. And third, she's putting the gas in there for him, like in West v. East Tennessee Pioneer Oil. That's the gas in the car. That car was not going to move if she had not been filling it up for 4 straight months. And again, this is what appellants seem to be arguing is for directed verdict standard. We're not here to weigh the evidence. Is there any material evidence from which a jury could reach this conclusion, taking all inferences in favor of the appellees?
But your first position is we don't even have to get to that, right?
Yes.
Because of the no post-trial motions.
Yes, Judge. It is too little and too late. There is nothing that has been preserved for any of these issues on appeal. Justice would have merited affirming this judgment anyway, but these appellants did not give the trial judge the required opportunity to do whatever, tinkering, reversals, new trials, anything that the trial judge thought was appropriate to send up a full and proper record to this court. The trial judge was deprived of that. I would hate to see what the courts would look like if plain error was a reason to avoid the entire post-trial process and kick the door open to the appellate courts on any and all issues, not those that were specifically reserved in a post-trial motion. I'll be happy to answer any other questions in my brief time left. Thank you, Your Honors.
I don't see any. Thank you. Mr. Mays?
Yes, Your Honor. I want to correct a few things. First, I thought Your Honors asked a good question about the time. The arrest charge 1 year prior to this accident was a paraphernalia charge, not a vehicle driving charge at all. The second part of that is there were not multiple narcotics in the system. The proof that was submitted was that Mr. Kellon had a valid prescription from a doctor. Those were admitted into evidence, his prescriptions that were filled at Walmart. And as Your Honors know, in Tennessee, the charge was not alcohol related at all. It's the fact that Tennessee does not have a measure of whether it is the limit, whether you're in the limit of the medication or not, meaning whether you've over medicated or under medicated. There's no law in Tennessee on that particular issue. But that morning, the proof was that he woke up, he took one Xanax pill, which he is prescribed. He drove from 7 o'clock in the morning till 12:30 with no accidents, no issues. Even the driver of the vehicle behind him said they didn't notice him swerving or exceedingly excessive speed. The reason I bring up, Your Honor, just to clarify the jury instruction is because that's the mechanism the trial court used in overruling the motion for directed verdict. So it's not necessarily I'm appealing the jury instructions, but the judge's ruling in that was all wrapped up in the reason for denying the directed verdict. And in regards to that, the court does have jurisdiction to hear this issue under Rules of Appellate Procedure 8A. Sorry, not that one, Your Honor. 13A, it says, except otherwise provided by Rule 3E, any question of law may be brought up for review and relief of any party. And I specifically cited some cases in my reply brief that address the fact that, like Story versus Langer, it says in the case had taken lengthy litigation over 2 years. The jury verdict to reach a jury verdict, and it would be a waste of time and expense when we'd already been denied the special and jury instructions, which we did object to. We already filed a motion for summary judgment and were denied. We filed a motion for directed verdict and was denied that as well. So the cases in my reply brief specifically talked about, we're not asking for a new trial here. We're asking for the law of negligent entrustment and how it's controlled. And as far as foreseeability, what Dane Kellon knew at the time, and this is in the facts, that Joshua Kellon completed drug rehab in January of 2017, 2 months prior to the accident. He completed that treatment. He had a valid driver's license, and he was driving for the purpose of business. And she did not even see them that day, which is why East Pioneer would not allow negligent entrustment to be charged, because she could have taken no action. And simply loaning money, since Your Honor's brought it up, it is in the record, volume 2, pages 208. She says she kept a running tally of any money that she let him use and put it on the refrigerator, and then he would pay me back. And that continues on to page 209 and 210.
Well, does that matter? I mean, if you don't have the money to pay for your vehicle, and someone comes in and helps you keep that thing running, does it matter that you pay them back? Didn't they allegedly negligently entrust you with the vehicle by helping you with the payments at the time you needed to make them?
In my opinion, no, Your Honor, because at the time of the entrustment, there's two definitions of time of the entrustment. The time of the entrustment is the purchase of the vehicle, which was bought by Joshua Kellon. Entrustment in East Tennessee was entrustment at the time that you put the gas in the vehicle, knowing that the person was intoxicated. That was the ownership and foreseeability. The law would simply change in negligent entrustment that ownership is no longer a factor. If this stands, imputed benefits would be the new standard, which could mean anything. You don't have to have ownership. It changes that. Foreseeability is extended because we have DWIs and DUIs from 14 years ago. We have a reckless driving from 2 years ago. So foreseeability comes anytime someone's charged with something. For instance, if someone had dementia, an older person, they were living with their children, you know they can't drive with dementia. You leave the home, they drive, they get in an accident. That would apply to the facts of the case if we change negligent entrustment.
Okay. Thank you. Thank you, Mr. Mays, Mr. Bass, and General Womack. Mr. Hivner, would you adjourn court, please?
This honorable court is now adjourned.
That was easy.
Thank you.
Thanks, everybody.
Thank you, Judge.
Mhm.